ये डिक्टेशन जो है वो पटना हाई कोर्ट में पूछा गया था। यही डिक्टेशन, तो यही डिक्टेशन हम लिखवा रहे हैं आप लोग को। तो स्टार्ट करते हैं, चलिए स्टार्ट। द appellants felt aggrieved by the decision of the respondent in not paying him any back wages for the period in question, filed writ petition in the High Court and prayed for grant of the relief of back wages. The learned single judge declined to grant any relief of back wages to the appellant and dismissed his writ petition. The division bench, in an appeal filed by the appellant against the dismissal of his writ petition, upheld the order of the learned single judge and dismissed his appeal, giving rise to filing of this appeal by way of special leave by the employee to this court. Having heard the learned counsel for the parties and on perusal of the record of the case, we find no merit in the appeal. The law on the question of award of back wages has taken some shift. It is now ruled in cases that when the dismissal removal order is set aside, withdraw by the courts or otherwise, as the case may be, directing employees reinstatement in service, the employee does not become entitled to claim back wages as of right unless the order of reinstatement itself in express terms direct payments of back wages and other benefits. Indeed, the employee, in order to claim the relief of back wages along with the relief of reinstatement, is required to prove with the aid of evidence that from the date of his dismissal order till the date of his rejoining, he was not gainfully employed anywhere. The employer too has a right to adduce evidence to show otherwise that an employee concerned was gainfully employed during the relevant period and hence not entitled to claim any relief of back wages. On proving such facts to the satisfaction of the court, the back wages are accordingly awarded either in full or part or may even be declined as the case may be, while passing the order of reinstatement. The courts have also applied in appropriate cases the principle of no work, no pay, while declining to award back wages and confining the relief only to the extent of grant of reinstatement along with grant of some consequential reliefs by awarding some benefits nationally, if any, in exercise of discretionary powers depending upon the facts of each case. Having seen the record of the case, we are satisfied that there was no evidence brought on record by the appellant under bracket employee in his writ petition to claim the back wages for the period in question either in full or part. Moreover, we find that the issue in question was raised in writ petition and not before the industrial or labor tribunal where parties could adduce evidence on such question. Stop.